Hello, and welcome back. You are once again listening to Passing the Baton. I'm Jared Hight from Tracktown Law, and today we're taking a deeper dive into Oregon's small estate affidavit, the probate shortcut that can move an estate from red tape to resolution in a matter of weeks instead of months. Before we dig in, a brief disclaimer. Although I am an attorney licensed in Oregon and Idaho, listening to this podcast does not create an attorney-client relationship, and nothing here should be taken as personal legal advice. Every estate has quirks, debts tucked in kitchen drawers, beneficiary forms hiding in HR files, so please consult a qualified lawyer about your specific situation. Now to the shortcut itself. Formal probate can feel like driving the I-5 corridor at rush hour, slow, crowded, and peppered with endless construction zones. Oregon's small estate affidavit is more like a country backroad bypass, paved, legal, and perfectly safe if you follow the signs. The legislature carved out this lane for modest estates so courts could focus their full docket on larger, contested, or complex matters. But modest has a precise meaning. On the date of death, the total estate cannot exceed $275,000, and that splits into two further caps: no more than $75,000 in personal property, and no more than $200,000 in real property. Personal property includes bank accounts, vehicles, stocks, household contents, and that vintage Fender guitar in the attic. Real property covers land and anything attached to it: a cabin, a farm, or a vacant lot intended for a future tiny home. Those numbers are cliffs, not speed bumps. An estate valued at $275,001 flunks the test and must take the full probate highway. We often shave values by verifying fair market numbers rigorously. Zillow's estimates swing like a kite. County assessor figures, a local realtor's comparative market analysis, or an independent licensed appraisal carry more weight and sometimes come in lower than online guesses, keeping the estate under the cap. Likewise, Kelley Blue Book values used for DMV transfers can dip below the optimistic private sale price heirs love to imagine. Timing also matters. An heir must wait 30 days after death before filing the affidavit. That pause serves two goals. It gives family members space for funerals and grief, and it allows the affiant, Oregon's term for the person completing the affidavit, to gather bank statements, locate the car title, and confirm the most recent mortgage payoff amount. Unlike formal probate, which can be filed the day after burial, the 30-day wait ensures no one rushes into court with half-baked figures. The affidavit itself is 12 pages of checkbox and blank lines that look simple until you realize every line is sworn under penalty of perjury. List every known debt, visa, medical bills, last month's phone bill, and every known heir, including estranged siblings and children from prior relationships. Miss a creditor or omit a half-sibling you'd rather forget, and the omission can boomerang months later as personal liability. Courts can revoke the affidavit, slap you with attorney fee claims, and in extreme cases, refer the matter for criminal prosecution. So the first rule is accuracy over speed. A week spent chasing down a forgotten Discover card can save a year of litigation. Filing fees are pleasantly modest, under $200 in most counties, because the court's role is limited. There's no publication, no surety bond, and no mandatory waiting period for inventory review. Once the clerk stamps it, you receive certified copies almost immediately. Those certified copies are golden tickets. They instruct banks to release accounts, the DMV to issue new titles, and county clerks to record deeds that move real estate directly to heirs. But freedom comes with strings. The affiant wears multiple hats: fiduciary, accountant, debt negotiator, and often grief counselor. They must pay debts in Oregon's statutory order. Administration costs, those filing fees, appraisal charges, and reasonable attorney bills are first in line, because the system wants the estate machinery funded. Next come funeral expenses up to $3,500. Upgrade the headstone to Italian marble, and the extra cost slides down the ladder like any other unsecured bill. Taxes follow. Final income tax, state estate tax if the estate creeps over the $1 million line, and any property tax arrears. Only after those obligations do general unsecured debts like credit cards get a slice. If assets run short, lower-tier creditors take proportional haircuts or get nothing at all. Pay Visa first and the Department of Revenue later, and you, the affiant, can end up sending checks from your own account to make the state whole. Copies of the filed affidavit must be mailed or hand-delivered to every heir and any known creditor within 30 days of filing. That notice gives them 60 days to object if they believe property was undervalued or debts skipped. Objections are rare when numbers are tight and heirs are siblings who talk daily, but throw in children from 2 marriages or a caregiver who received a suspicious payable on death account, and you may see formal objections. At that point, the court can elevate the case to full probate or hold a hearing to resolve the dispute. In summary, do the math right, communicate early, and objections usually dissipate. Who benefits most from the affidavit route? Picture a widowed mother who owned a modest ranch house worth $180,000, drove a 2010 Subaru worth $5,000, and kept $25,000 in her local credit union. Her heirs are 2 adult children who get along. That estate sails through the affidavit path. Closing can take 6 to 8 weeks, start to finish, and legal fees are small. Now picture the same house, but mom ran a home-based bakery and died with prepaid wedding cake contracts, pending tax filings for business income, and a leased commercial mixer. Even if the dollar value fits inside the caps, the business risk complicates matters. Creditors may surface months later with breach of contract claims, so full probate, with its creditor deadlines and judicial oversight, may be safer. A word of caution on life insurance and retirement proceeds. Payouts directly to named beneficiaries do not count toward the small estate threshold, which is great for heirs. But if no beneficiary is named, or all beneficiaries predecease, the money drops into the estate and inflates the value. Periodically download beneficiary reports from your insurer and custodians. One fast update today can keep your estate from tipping over the $275,000 cliff tomorrow. Real property deeds require precision. The affiant records a certified copy of the affidavit accompanied by a short conveyance document describing the property and naming the heir. County recorders scrutinize legal descriptions. A missed lot number can cloud title and stall a future sale. Hire a title company to prepare the deed if you are not comfortable with metes and bounds language. After assets are distributed and debts paid, the affiant keeps receipts for 4 years, the statute of limitations on creditor claims. Scan everything to PDF and back it up. Courts rarely reopen a closed small estate filing, but when they do, clear proof beats faded memories. Why choose the affidavit instead of a revocable trust established before death? 2 reasons. First, some owners never get around to trust funding, and their estates are small enough that the affidavit is faster than trust administration. Second, trusts carry annual maintenance, funding new assets, updating schedules, while the affidavit is a one-off procedure. If the entire net worth comfortably fits under the statutory caps, you might rationally skip trust drafting fees and rely on the affidavit route. Yet remember that real estate appreciation and market gains can push value above the cap over time. A house bought for $140,000 10 years ago can now appraise for double that. Estate planning should be forward-looking, not frozen in last decade's numbers. Let's finish with the checklist of common mistakes. One mistake is filing too early, eager to prove you're on top of things, only to realize you forgot the decedent's treasury bonds. Amending the affidavit is possible, but invites judicial questions and heir suspicion. Another slip is using online valuation without documentation. Courts do not accept my best guess when a sibling challenges the number. Save screenshots, print county records, and attach broker pricing opinions. Finally, do not skip the 30-day post-filing notice to heirs and creditors. That courtesy triggers the objection window and prevents claims of secret dealings later. Curious whether an estate you're handling meets Oregon's small estate requirements, or worried your own estate might overshoot the cap in a few years? Visit tracktownlaw.com. I can walk you through live numbers, spot trouble before it starts, and draft the affidavit so you can move from paperwork to closure while memories are still fresh. Next episode, we'll explain Oregon's $1 million estate tax threshold and why even middle-class homeowners need to pay attention.